All right, good morning. All right, it's my understanding that defense is resting, is that correct? Correct. All right, I'm not going to bring the jury out just to take them back in, so after we finish our motions and they come out, I'll let you say that, yeah, okay, let's just do it that way. All right, so based on them resting, you have a motion?
Yes, sir.
And I did receive your memo ahead of time, so I have reviewed that. Okay, I have that, okay. Yes, sir?
I haven't received anything from them. I don't know whether they filed it.
I think it's just going to be oral arguments. Yes, sir.
Good morning, Your Honor. May it please the court, Ben Chu for plaintiff Johnny Depp. Mr. Depp hereby moves to strike defendant Amber Heard's counterclaims because Ms. Heard has not proven by clear and convincing evidence that Mr. Waldman made the 3 allegedly defamatory statements with actual malice.
Right, but clear and convincing is not my motion to strike standard.
Understood, Your Honor.
Okay.
And we have cited the standard in our brief.
Thank you.
Moreover, Your Honor, the court should also strike defendant's claim for immunity and attorney's fees based on Virginia's anti-SLAPP statute, as she is not entitled to immunity under the statute. Because we know that the court has carefully reviewed our motion papers, I will just hit some of the salient points.
Thank you, sir.
Thank you, Your Honor. I would mention, however, Your Honor, that because this is not included in our brief, that there is no record evidence whatsoever that Mr. Depp even saw any of the 3 statements that Mr. Waldman made prior to being served with the counterclaims in this action, which we believe is relevant to many of the legal standards. And as Your Honor is aware, Ms. Heard had signaled for the past week that she was planning to call Mr. Depp in her case in chief, and it was our anticipation that she would try to fill what we believe is a gaping hole with respect to the elements of her proof. Again, there's no record evidence whatsoever that Mr. Depp ever saw any of the 3 statements about which Ms. Heard is purportedly suing him for $100 million. As Your Honor is aware, the elements of defamation are as follows. 1, publication of 2, an actionable statement with 3, the requisite intent. See Thorpe versus Sanders, 285 Virginia 476 at 2013. The requisite intent for defamation against a public figure is actual malice. That is, the statement must be made with knowledge that it was false or with reckless disregard of whether it was false or not. See Sanders v. Harris, 213 Virginia 369 at 372, a 1972 case. See also Jackson v. Hartig, 274 Virginia at 2019. Reckless disregard, as Your Honor is aware, quote, is not measured by whether a reasonably prudent person would have published or would have investigated before publishing, ellipsis. There must be sufficient evidence to permit the conclusion that the defendant, in fact, entertained serious doubts as to the truth of his publication, unquote. St. Amant versus Thompson, 390 U.S. Supreme Court, 727 at 731. Your Honor, the evidence shows that Ms. Heard cannot prevail on her claim because she cannot and did not establish that Mr. Waldman made the statements with actual malice. Mr. Waldman testified that he conducted extensive investigation and reasonably believed that the 3 statements he made were true. Ms. Heard presented nothing to contradict that undisputed fact. Ms. Heard has no evidence of direct liability because obviously, Your Honor, we need to talk about direct and vicarious liability, but it bears noting that she has no evidence of direct liability and cannot prove actual malice by Mr. Waldman when making the 3 statements at issue. It is undisputed that Mr. Depp did not make any of the 3 statements at issue in Ms. Heard's counterclaim. Moreover, in order for Mr. Depp to be liable for the conduct of one of his attorneys, There must be some showing that he directed, participated, or otherwise authorized Mr. Waldman to make the statements at issue. There is no such evidence on the record that Mr. Depp directed or otherwise authorized Mr. Waldman to make the 3 allegedly defamatory statements at issue in the counterclaims. Indeed, there is no evidence of any communication or coordination between Mr. Depp and Mr. Waldman regarding the counterclaim statements or anything else. For this reason as well, Your Honor, Ms. Heard cannot meet her burden of proving that Mr. Waldman was acting within the scope of his employment as our agency on behalf of Mr. Depp. Again, it bears noting that there's no evidence that Mr. Depp even saw the statements by Mr. Waldman until he was served with the counterclaims well into this case. It was more than a year after Mr. Depp filed his complaint, and Ms. Heard lost a series of motions to dismiss that she finally asserted her counterclaims, most of which have already been dismissed by opinion letter of this court. Whereas here there is no evidence of direct liability, Ms. Heard must rely on a theory of vicarious liability to hold Mr. Depp liable for the actions or statements, rather, of his purported agent, Mr. Waldman. Vicarious liability is by definition, quote, liability for the tort of another person, unquote. So to hold Mr. Depp liable for Mr. Waldman's statements, Ms. Heard must establish that Mr. Waldman himself committed all the elements of defamation. I know the court's familiar with this, so I'll try to run through it quickly. See Parker versus Carillon Clinic, 296 Virginia 319 at 332, a 2018 case. Quote, vicarious liability is liability for the tort of another person. It necessarily follows that a claimant cannot make out a case for vicarious liability against an employer without first proving that the employee committed a tort within the scope of his employment. See also Roughton Pontiac Corp. Versus Alston, 236 Virginia 152 at page 156. Which standard Ms. Heard has not met? And Your Honor, we cite a string citation to cases from other jurisdictions, which we obviously are not binding on the court, but we believe are influential. We presented those to the court for its review. It is Ms. Heard's burden to prove by clear and convincing evidence, or ultimately, to prove actual malice by Mr. Waldman, not Mr. Depp. And while it is well settled law in Virginia, as Your Honor has pointed out last week, that an agent's knowledge can be imputed to a principal, and this is the were called to the penthouse on May 21, 2016, and saw no signs of injury on Ms. Heard's face, as well as, quote, Ms. Heard's own witnesses who have testified in various forums at various times that there were no injuries to her face whatsoever between May 21st and May 27th, 2016, when she walked in to court with her publicist, her lawyer, her former best friend who no longer speaks with her, for a no-notice ex parte TRO. Some of the witnesses whom Mr. Waldman has cited, they include Laura DeVenier, Melanie Iglesias, who, as Your Honor recalls, was Ms. Heard's makeup artist, who decided to end any professional or personal association with Ms. Heard, Samantha McMillan, Hilda Vargas, Isaac Baruch, Trinity Esparza, Cornelius Harrell, Alejandro Romero, and Brandon Patterson, just to name a few. No reasonable jury could find that Mr. Waldman acted with actual malice in making the allegedly defamatory statements. He was not present for the alleged incidents. He has no personal knowledge of any of the alleged incidents. What Mr. Waldman knows is a product of the legal work he did, the sleuthing he did on behalf of Mr. Depp. Ms. Heard cannot possibly show that Mr. Waldman acted with actual malice, and her defamation claim must fail. 2, Mr. Waldman is an independent contractor, not an employee. It is axiomatic, Your Honor, that a person who hires an independent contractor is not liable for the independent contractor's actions. See Sanchez versus Medicorp Health System, 270 Virginia, 299 at 344. An independent contractor is a person who is engaged to produce a specific result, but who is not subject to the control of the employer principal as to the way to bring about that result. See Atkinson versus Sachno, 261 Virginia, 378 at 284. That's a 2001 case. An outside lawyer retained by a client in connection with litigation is an independent contractor. See King versus Dalton, 895 F. Sup. 831, Eastern District of Virginia, 1995, where Judge Ellis, a legendary jurist known by all Virginia practitioners, held that, quote, a law firm attorney working with a client is nonetheless an independent contractor and is not an employee of the client corporation. In that case, the employer was a corporation, but the same logic applies when it's an individual like Mr. Depp. That was Mr. Waldman's role. Indeed, clients hire lawyers to obtain specific results, or to try to obtain specific results, but they do not control the means by which the results are accomplished. Lawyers, as Your Honor has reminded us, are subject to professional obligations to exercise independent professional judgment. We are not at the whim of our clients as much as we want to serve them. See Virginia State Bar Professional Guidelines, Rule 1:2 and 2.1. And just to quote 2.1, in representing a client, a lawyer shall exercise independent professional judgment, unquote. Mr. Waldman is, as a matter of law, an independent contractor, and Mr. Depp cannot be held responsible for any alleged tort by his attorney, particularly for statements about which he was unaware until he was sued for them. Mr. Waldman testified, and it's unrebutted, that he has his own law firm. He's not an employee of Mr. Depp. Mr. Depp or none of his loan-out companies have issued him a W-2, and Mr. Waldman provides legal services to clients other than and in addition to Mr. Depp, and that's found at the transcript, page 6020 through 21. All of that is unrebutted by Ms. Heard. Mr. Waldman's statements, the third reason for which we respectfully submit the counterclaim should be stricken, is that Mr. Waldman's statements were protected opinion. And I won't run through all of that, but very briefly, taken in their proper context, the counterclaim statements are non-actionable expressions of opinion entitled to protection under the First Amendment. See Gertz versus Robert Welchink, 418 U.S. 323 at 339. That's a 1974 case from the United States Supreme Court. See also Shacker v. Bufault, a Virginia Supreme Court case found at 290 Virginia 83, a 2015 case, noting that where, quote, all sides of the issue, as well as the rationale for the speaker's view were exposed, the assertion of deceit reasonably could be understood only as the speaker's personal conclusion, unquote, and finding an accusation of deceit to be opinion. In context, Your Honor, any reporter or any reasonable reader would understand and expect a lawyer associated with Mr. Depp, as Mr. Waldman was, to challenge Ms. Heard's version of the inherently controversial events of the parties' marriage. Just as Ms. Heard's lawyers were quoted challenging Mr. Depp, and Your Honor will remember the context of these quotes that were in a British tabloid where Mr. Waldman's statements were buried well into article in which both points of view were clearly expressed, and Mr. Waldman was clearly identified not as an independent expert on the U.S. Constitution, but as one of Mr. Depp's attorneys. C. Chavez, 230 Virginia 112 at page 119, quote, the most unsophisticated recipient of such a claim, i.e. any reader of the British tabloid, made by a competitor against another could only regard it as a relative statement of opinion grounded upon the speaker's obvious bias, unquote. Mr. Waldman has never did anything to hide his support and belief in Mr. Depp. Finally, Your Honor, and for the rest, ultimately, Mr. Waldman's statements reflect the existence of two competing narratives and are merely his subjective view about events that he never claims to have witnessed, and there was no doubt about that. Turning to the second part of the argument, which will be more abridged, Ms. Heard is not entitled to anti-SLAPP immunity. As a threshold matter, Virginia Code Section 8.01-223.2, which is, as Your Honor well knows, is the Virginia anti-SLAPP statute amended most recently in 2019, provides in relevant part, quote, the immunity provided by this section shall not apply to any statements made with actual or constructive knowledge that they are false or with reckless disregard for whether they are false. Here, in addition to Mr. Depp's testimony, several witnesses have testified that A, they never witnessed Mr. Depp abuse Ms. Heard, and B, that they observed Ms. Heard without any injuries, marks, bruising, swelling, etc., during periods when Ms. Heard claimed to have injuries, marks, bruises, etc. Such witnesses include, but are not limited to, Isaac Baruch, Kate James, Dr. David Kipper, Nurse Debbie Lloyd, Officer Sines and Haddon, Officer William Gatlin, and former U.S. Marine Starling Jenkins. Ms. Heard's request for anti-SLAPP immunity should be stricken, and even if there were disputed facts as to that, the anti-SLAPP immunity does not apply because the defamatory implication of Ms. Heard's statements are not solely relating to a matter of public concern, as is required under the statute. As has become quite clear, Your Honor, Mr. Depp is not suing about any of the public policy commentary made by the ACLU when it drafted the op-ed, and Ms. Hurd put her name to it. What he is suing about here are the 3 statements that were directed at him. He has no issue with women's rights. He supports women's rights. In fact, he was the one, Your Honor, as Your Honor knows, who made that first $100,000 contribution to the ACLU, and he made it also to the CHLA.
Your Honor, at this point, I'm going to object. Mr. Chu has largely just read his brief and confined his arguments to those directed in the motion, but like we saw with the last motion to strike, he's now directing his arguments to something other than what's at issue here, and I would object because I think making an argument not to you but to the cameras, it's disrespectful to the court and to everyone's time, and it also threatens to undermine the integrity of this process and risk the jury being influenced by outside factors.
Well, it's his argument. I'll allow him to do his
Thank you.
Thank you.
Thank you, Your Honor. As I was trying to say, what Mr. Depp is suing about are the 3 statements. And it's very clear, despite the pious opening statement about the First Amendment, that with the testimony of Terrence Doherty and the emails that were admitted as exhibits, that the ACLU and Ms. Hurd were conspiring to make it very clear that those 3 statements were related to Mr. Depp, because otherwise nobody had any interest in the article. And it's crystal clear from that. They wanted to time this thing with the release of Aquaman, which was her first film of any significance in terms of popularity, and to do that. That's very clear. So the charade that this had something to do with public policy is risible, and that is not why the anti-SLAPP protections were enacted. They were enacted to protect the rest of the article, not what Mr. Depp is suing about. As generally analyzed by the courts, a matter of public concern is one which relates to, quote, a matter of political, social, or other concern to the community, unquote, as opposed to a matter of only, quote, personal interest, unquote. That's Connick versus Myers, 461 U.S. 138 at page 146. Instead, the defamatory implication at issue in each of the 3 statements at bar relate to the personal grievances between Mr. Depp and Ms. Hurd, which does not rise to the level of a matter of public concern with broader implications for society beyond the 2 litigants in this action any more than Mr. Waldman's statements. I mean, adding the gloss of public policy might immunize the statements that relate to public policy, but those are not at issue here. Mr. Depp agrees with those statements. We're talking about the 3 statements that they very intentionally and very cleverly put in to make it clear the implication that it was about Mr. Depp. They had lawyers from the ACLU working around the clock with Eric George to be as clever about this as possible. And Your Honor remembers the testimony of Mr. Doherty about the consternation at the ACLU when they realized that USA Today and everybody else who read the article knew darn well that this was about Mr. Depp. This cannot be protected by the anti-SLAPP statute. It is a cynical runaround. And I think now that we have the undisputed evidence from the ACLU in the form of the testimony of Terrence Doherty, who is not only their corporate representative, he was their general counsel. He is a brainiac lawyer. They knew exactly what they were doing, Your Honor. And he referred to testimony of a woman at the ACLU who said she had nightmares about Ms. Hurd, and he expressed no concern about that. Now, that was either because they knew about that was either a reference to this game they were playing with the op-ed or the conspiracy they had to cover up her failure to make the donations. The donations became pledges, but we have evidence that she refused to sign the pledge card. So she's caught either way. Simply stated, Your Honor, Mr. Depp is not suing Ms. Heard for making statements about society in general. I think that's very clear from the record evidence. Mr. Depp is suing her for publicly naming him as an abuser by implication and forever tarnishing his good name, an act that, coming from an ex-spouse, is fundamentally personal in nature. For that reason as well, Your Honor, Virginia's anti-SLAPP statute is not applicable. And based on the foregoing, Your Honor, Mr. Depp respectfully submits that the court should grant plaintiff's motion to strike the counterclaims and also strike her claim that she is immune under the anti-SLAPP statute. Thank you very much, Your Honor.
Thank you, sir. Yes, sir.